Welcome back to the Constitutional Clarion. This video is a response to a viewer request to understand how the Constitution operated during the COVID-19 pandemic, particularly in relation to the closure of state borders. While this video is going to address that issue of border closures, I will do a separate video later on about COVID-19 and its relationship to human rights, such as freedom of movement and freedom of speech. The best place to start, as always, is with the text of the Constitution itself. Section 92 of the Constitution states that interstate trade and commerce, and what it rather curiously describes as intercourse, which in this context means the movement of people and animals and goods across state borders, shall be absolutely free. Now those words, absolutely free, led many to assert that state borders could not be shut as there is a constitutionally guaranteed right for people to travel across state borders. The words absolutely free, they said, meant just that, and they didn't permit of any restrictions. But that's not the whole story. The words absolutely free were described by George Read during one of the Constitutional Convention debates of the 1890s as a little bit of layman's language. And that little bit of layman's language, rather than the pernickety lawyer language, has actually caused no end of trouble ever since, because it doesn't actually say what was intended. And that's the essential problem. Now we know this from the context of Section 92 in its relationship to the rest of the text of the Constitution, the history of the drafting of Section 92, and its later interpretation by the High Court. It's plain from the text of the Constitution that some restrictions on interstate trade, commerce, and intercourse are permitted. The Commonwealth was given the power under Section 51(1) of the Constitution to regulate interstate trade and commerce, which includes, of course, placing some limits on them. The Commonwealth was also given the power under Section 51(9) to make laws about quarantine, which of course could prevent diseased people, animals or produce from travelling, including across state borders. The trade and commerce power and the quarantine power are concurrent powers of the Commonwealth, and that means that they're powers that can also be exercised by the states, and of course the state legislation is overridden if the Commonwealth enacts an inconsistent law, but otherwise states can enact laws about interstate trade and commerce, subject to Section 92, and quarantine. Section 112 of the Constitution also recognises that states may levy charges for inspection laws that ensure that goods and animals crossing the border are not diseased. Accordingly, Section 92 cannot amount to an absolute right to cross state borders where there are risks of spreading disease. It's also clear from the Constitutional Convention debates of the 1890s and the legal opinions written by the framers of the Constitution in the first decade after Federation that absolutely free did not mean absolutely free of any restriction. According to Sir Samuel Griffith, later the High Court Chief Justice, Section 92 was actually directed at being absolutely free from taxes and imposts upon border crossings. Richard O'Connor, who was also later to become a High Court judge, said during the Convention debates on the 22nd of September in 1897 that the states would retain a right of self-protection so that they could prohibit diseased persons and animals from entering the state without breaching the freedom of trade and commerce and human intercourse. Another framer of the Constitution, Patrick Glynn, writing later as Commonwealth Attorney General in 1909, said that a state inspection law would be unconstitutional if it imposed an unnecessary or unreasonable burden upon interstate commerce. He considered that a law that imposed a complete prohibition on certain kinds of plants being brought into a state, healthy and diseased alike, imposes an unnecessary burden on interstate commerce and cannot be justified on the ground that it is a precautionary measure against the introduction of disease. If the law were conditional rather than absolute, and the conditions were neither unreasonable nor greater than reasonably necessary to meet that ostensible purpose, then the law would be valid. Now, the reasoning in that opinion by Paddy Glynn is the same reasoning that you see appearing through High Court jurisprudence ever since. So, for example, let's take a 1928 case, and here 3 judges of the High Court said, "The establishment of freedom of trade between the states is perhaps the most notable achievement of the Constitution. Yet it would be a strange result if that achievement had stripped the states of power to protect their citizens from the dangers of infectious and contagious diseases, however such diseases arise." Their Honours concluded that a New South Wales law that prohibited diseased cattle from crossing the border into New South Wales, and which required, in some cases, for those cattle to be destroyed if they did enter the state, that law did not breach Section 92 of the Constitution. Now, the court also took a similar view in 1935 in relation to a law about diseased potatoes. A law that banned diseased potatoes from entering a state was valid, but a law that banned all potatoes without actually checking them for disease, just to exclude the risk of any disease, was considered by the High Court to be invalid because it was disproportionate. But what about people rather than diseased cattle or potatoes? Could a state shut its borders to prevent people from crossing so that an infectious and deadly disease could not enter a state? This dilemma was first faced in the wake of World War I as troops began returning home to Australia. When the Spanish flu began to spread in late 1918, Australia had 2 layers of protection: the external border of Australia and borders within Australia between the various states. Soldiers returning from the war were quarantined on their ships in Sydney Harbour or at North Head Quarantine Station, so the disease did not enter into Australia. On one occasion, soldiers were housed in tents on North Head because there wasn't enough room in the quarantine station, and they found that North Head was actually infested with many poisonous snakes. Now, having killed, apparently, 67 snakes on the first night, the troops then mutinied. Fully masked and in military formation, that morning they marched to the gates of the quarantine station. They defied the guards on duty to shoot them, and unsurprisingly, the guards were not prepared to shoot at hardened Australian troops who had risked their lives to defend Australia overseas. The troops then marched onto a ferry, steamed across to Circular Quay, and after some negotiations proceeded to the Sydney Cricket Ground, where they actually served out the rest of their quarantine, but without the snakes. The second line of protection was state borders. In November 1918, an intergovernmental agreement was reached between the Commonwealth and the states, and it provided that if a state identified that it had a Spanish flu infection, it would notify the Commonwealth immediately. The Commonwealth would then take control of the state's borders, closing them to neighbouring states and then reopening them when the neighbouring state was also infected. Victoria did become infected, but it didn't admit it. It hid the fact until a doctor there actually blew the whistle. But by then, the Spanish flu had already spread from Victoria into New South Wales. A furious New South Wales government slammed shut its border with Victoria and declared that the intergovernmental agreement was at an end. From then, it was every state for itself. The Commonwealth tried to reassert control, but its threats were ignored. The states closed or opened their borders in their own interests. I think this probably rings a bell with you in terms of what happened 100 years later. But it is interesting to know that 100 years earlier, exactly the same approach was taken. Western Australia even went so far as to seize and impound the transcontinental train as it entered into Western Australian territory, placing all the travellers in quarantine. The Commonwealth objected that this breached the Intergovernmental Agreement of November 1918 and possibly even the Constitution. But Western Australia just didn't care. The Perth Daily News said this: "Had we admitted the transcontinental travellers, we might have suffered infection. There was a chance. We preferred to flout authority, break the agreement of November, and even perhaps fracture some constitutional statute rather than court the disaster of the entrance within our borders of the Black Plague." So that's how seriously they took it. And even more interestingly than that, the Western Australian Premier, Henry Lefroy, found himself actually on the wrong side of the border when it shut. He was actually in Melbourne, where he'd been attending a Premier's conference. The acting Western Australian Premier, Hal Colbatch, who was the one who shut the border, then resisted the pleas of his own Premier and the Prime Minister to reopen the border. His actions in closing the border were wildly popular in Western Australia. So popular, indeed, that Colbatch was soon after made Premier himself, despite being a member of the upper house. Now, while Spanish flu did eventually make it into Western Australia, the delay that was caused by the shutting of the border did save many lives. At that time, Queensland also shut its borders, including to communities that lived along the border. It actually charged people a considerable amount to enter quarantine camps, and it required them to receive 2 compulsory vaccinations before they were allowed to enter the state. There were also 2 familiar stories to us now about lockdowns, the closure of schools, disagreements about mask wearing, vaccine mandates, and quack cures. But despite all the controversy, no one back in that period, around 1918, 1919, no one actually initiated any constitutional challenge to the border closures. So we don't have any authority about it from then. Now, 2 other occasions where there were notable restrictions upon cross-border movement include during war and also to prevent the spread of leprosy in the north of Australia. Now, for the story about war, have a look at my other videos, and I have to say it's a cracking story about Dulcie and Ada, who are the Thelma and Louise of Section 92 of the Constitution on their great train trip from Sydney to Perth without authority during World War II. In Western Australia in 1957, there was also a failed challenge under Section 92 to the validity of the leper line, which was introduced to prevent the spread of leprosy. In cases where the High Court interpreted that intercourse limb of Section 92 of the Constitution, it first asked whether the law impeded intercourse, being the movement of the people or the goods across the state borders. If so, it then asked whether the law was reasonably necessary to achieve a legitimate end, such as protecting public health, safety, or the environment, and there was no other equally effective means available to achieve that purpose which imposed a lesser burden on interstate intercourse. In such a case, the law would be valid. Now this, as you can tell, is consistent with that opinion I told you before by Paddy Glynn about unreasonable limitations, and also the jurisprudence of the High Court about diseased potatoes. So there's a long history of this. Now this history gives us quite good context for what happened when the COVID-19 pandemic hit Australia in 2020. Just as in 1919, states were prepared to close their borders to prevent the spread of this disease to them and their people, at least before there were vaccinations that were available to help limit its very serious effects and to prevent the hospitals from becoming overwhelmed. Tasmania's Mercury newspaper gave as a headline in March 2020, "We've got a moat and we're not afraid to use it." Western Australia, just as it did in 1919, shut its border to keep COVID out and was again largely successful in doing so, probably saving many thousands of lives, including, by the way, the lives of people who vociferously complain about the border closures. The border closure not only protected the people of Western Australia, but also the mining industry, which was really important to maintain Australia's economy during the COVID-19 pandemic, and it also protected vulnerable Aboriginal communities. The Western Australian border closure was criticised by the Commonwealth, and it was challenged in the High Court by Clive Palmer, who was refused entry into Western Australia. Palmer claimed that his physical presence was needed in Western Australia to run his businesses there. Western Australia said, however, that Palmer could use Zoom like everybody else had to. As the parties could not reach an agreement about the facts in relation to the risk, this aspect of the case was then sent off to the Federal Court to determine. Justice Rangier heard evidence from epidemiologists about the level of risk involved in the spread of COVID-19 and in relation to the different measures to prevent its entry into the state. He determined that a precautionary approach should be taken to protect the community. The state's capacity to provide safe quarantine facilities was limited, and the risk of COVID spreading was high, with potentially catastrophic results. This was, of course, all before vaccinations had become available to deal with COVID-19. On the basis of Justice Rangier's findings, it could be concluded that the border closure was reasonably necessary and proportionate to achieving the legitimate end of protecting public health. Unlike the case about the diseased potatoes, there was no ability to know with certainty whether a person entering the state was actually carrying COVID-19. You couldn't tell by an ordinary inspection in the same way that you could in relation to a potato. The High Court then reconsidered the test that should be applied to see whether a law breaches Section 92. First, it looked at whether the law discriminated against interstate trade or intercourse. In this case, the law did, by preventing the movement of people across the border. Second, it looked at whether there was a legitimate purpose for the law and whether it was proportionate to achieving that purpose. In this case, the High Court held that there was a legitimate purpose of protecting public health, and that the law was proportionate to achieving that purpose. There were inbuilt restrictions in the Western Australian law on the use of emergency powers. They could only be exercised for the purpose of managing the adverse effects of a declared emergency, and an emergency could only be declared where extraordinary measures were required to minimise loss of life and harm to health. If the powers were exercised for other purposes, such as political purposes, then their exercise would have been invalid. But the court considered this was not the case here. Chief Justice Kiefel and Justice Keane said, quote, "It may be accepted that the restrictions are severe, but it cannot be denied that the importance of the protection of health and life amply justifies the severity of the measures," unquote. Although the terminology has differed over the years, the High Court has consistently held that Section 92 is not absolute in its effect, despite its use of those words absolutely free. The interstate movement of people may be restricted, but only where there is a legitimate purpose, such as the protection of public health and safety, and only if the law is proportionate to achieving that legitimate purpose. So that little piece of layman's language, those words, absolutely free, does not give an absolute guarantee of a right to cross state borders. But it does still protect against laws that prevent border crossing for an illegitimate purpose, or where the law is disproportionate because the burden of the restriction exceeds the benefit of the protection that it gives. I hope this helps you to understand how the High Court has dealt with Section 92 and its interpretation in relation to the closure of state borders. It is, of course, a very controversial issue and one which people will no doubt have very strong views about. Thank you for watching the Constitutional Clarion again, and I, as always, look forward to seeing you again next time. Goodbye.